Hi guys, this is Mike Edwards again, talking to you about another topic in criminal law that tends to come up a lot. And I'm going to try to give you my thoughts on this question because I answer it at least once a month to people that call. A situation where you have not been charged with anything and we're catching it early on there. The officer is investigating an allegation. Somebody's accused you of doing something, or maybe you're implicated as someone who may have been involved in the situation, and the officer either comes to your door or usually will call you on the phone. This is Officer X, and I would like to know if you'll come down and speak to me about such and such situation. Tell me what you know about it. Here's my number, give me a call, or maybe get you live and tries to set up a time to come down to talk about it. Okay. Now sometimes I don't get that call. Sometimes people just go on down there and start talking to the officer, and then if they get charged, which happens quite a bit, then they come to me. And then I get a copy of the statement that was made later on as part of discovery, or maybe just informally from the DA, but I get a copy of it. So now for the purposes of this segment, you call me and you say, what should I do? Should I go talk to the officer? I'm going to generally tell you no. Now, why would I say that? Officer may have said, I just want to clear this up to make sure that you're not involved. There's no telling what the officer's going to say to you to get you to come down and talk to him. I've been a chief assistant DA for 8 years. I've been defense attorney now for 27 years. That's 35 years, believe it or not. So given that 35-year experience, what does that tell me? When an officer has got enough to charge you, if he's got enough evidence to charge you, he doesn't need to talk to you. And generally speaking, will not talk to you. Now, why not? You know, the old cop shows back in the day, they always had this thing, right? You have the right to remain silent. Anything you say can be used against you. And I get people all the time that get charged and they say, that cop violated my constitutional rights. He didn't tell me he didn't read me my rights. So you need to throw this thing out. That's what watching old cop shows will do. I watched them too, and they were good. Some of them were really good back in the day. No, that's not the rule. In fact, strangely enough, back in those days, usually the cops would start out and read you those rights. That's the reason everybody in America knew them, because you saw them on Barnaby Jones or something, some TV show. Columbo or whatever it was. But that's just not what happens. And somewhere, I guess it's probably in the 90s, about the time I was into my DA career, before I went on to be a practitioner, defense attorney, they started actually advising the officers not to advise people of rights. Now, why would they do that? Well, under the law, if you are charged with a crime, and if the officer sits down and interviews you, now let's say the officer has you dead rights, he's got you, he's got you, well, let's say he's got a good case. Let's don't say dead rights. Say he's got a really good case. He feels like he's got a good enough case that he doesn't need a confession because he can prove it. And a lot of times they do have enough evidence where they don't even need a confession. It's always good to have one. But the thought was given amongst law enforcement community, if officer's got a good case, and then if he interviews you and you say, I didn't do it. Well, if that's what happens, then sometimes that statement of I didn't do it can get to the jury during your trial. And if you've got a slick defense attorney like A. Michael Edwards, he may find a way to keep you from having to testify and get your statement into evidence in the state's case to give the lawyer, the defense lawyer, the closing argument in a trial. Now I know it's a pretty complex tactical thing I just explained there, but suffice it to say, they started instructing officers, don't necessarily interview someone and let them proclaim their innocence. If you've got a good case, make them have to proclaim their innocence to the jury, which forces them to get on the stand. And it gives the DA the last argument before the jury, which is always a plus. So anyway, that's kind of how it all got tied up there. Officers doesn't have to give you your rights under the Constitution. It's just if you are in custody, the officer, if you're not free to leave in custody, if the officer questions you about your involvement in a case, you have to be advised of your right to remain silent in order for the statements that he gets from you to be admissible in court. That's what the rights advisement is. So let's go back to my original example. Officer wants you to come down there and give a statement. If he wants you to come down and give a statement, hello, he needs a confession from you. He needs some more information from you because his case is either marginal or he can't tell whether the person that's accusing is telling the truth or not. There's something wrong with his case. If he's got a good case, he goes to the magistrate and gets a charge and comes out to see you. And at that point, he determines, do I want to talk to the defendant to lock it down with a confession or not? You know, a smart officer goes and gets his warrant if he's got enough. If he's got enough, he goes and gets his warrant. He goes and initially meets with you, the defendant who's charged. A good sharp officer is experienced enough to be able to tell in his first interactions if you're getting ready to give a confession or not. And if you're a big tough guy and he knows, and you just start shouting, I didn't do it at the very get-go then he's not going to advise you your rights because he knows what you're going to say is I didn't do it. But if you're kind of sheepish when he comes to arrest you and says, oh, okay, I want to talk about this, he's probably going to then sit down, read your rights, get the confession, case closed. And then you come to me and want me to defend you, which I can do, but we're not talking about a trial at this point, right? And then you say, but I want a trial. I changed my mind. I didn't mean to confess. I wasn't telling the truth. Okay. All right. So what I'm trying to say is this. If an officer wants to talk to you, he doesn't feel like he's got enough to go get a warrant, or he doesn't feel comfortable enough. So why in the world do you want to help him make his case? That don't make sense. Don't do that. I always say no. When somebody calls me, I'll say, my advice is no. If you want to do it, that's fine. My advice is no. I don't see any benefit to you. The way you do that is this. Maybe the officer really wants you, not necessarily wants you, but wants somebody that is in the chain, maybe higher up the ladder. It might be a drug charge, and you're just a small fish in the pond, or maybe doesn't have enough to charge you, but you have some information. Well, don't talk to the officer. If you get charged, then I, as your attorney, can go to the DA and say, I understand your officer wants to talk to my client. What's in it for me and him or her? What's in it for us? We might be willing to talk. You give up your leverage if you just